Counsel, you want the rebuttal time?
5 minutes, Your Honor.
Sure, go
May
ahead.
it please the Court, I'm Richard Lerner. I represent Genie Industries, who respectfully requests that the decision of the Appellate Division First Department be reversed and the complaint be dismissed. And in doing so, this Court hold, in accordance with every other high court that has considered the issue, that there is no duty to retrofit. This case...
Is that what the jury found?
Your Honor, the jury found many things, but in Voss, in Caprara, in Cover against Cohen, this Court held that the focus of a strict products liability case is the time of sale. And yet days and days of testimony in this case was spent on what occurred after sale for 11 years.
But the jury found the product was defective as designed, as originally designed. Why doesn't that make any error in the other claim harmless?
Well, let me address that in a moment. I'd like to point out first that the claim of a duty to retrofit permeated this trial and tainted the entire verdict. As this Court has held, such evidence post-sale is prejudicial.
But you don't argue that they didn't make and prove a design defect case.
The AWP was a new and improved product. It was not the PLC line. The PLC line.
No, but I mean this is a garden variety design defect case. I hate to say there's a garden variety of those, but and interlocks seem to show up every single time. That's not new. None of that's new.
It's not new, but it was not reasonably practical.
Your expert said that. Their expert said the opposite.
No, their expert did not. Their expert said that an interlock could have been applied,
right.
But he didn't demonstrate that it would have worked in the field.
But it wasn't this kind of a classic product liability, expert battle?
It was not, because the plaintiff's expert didn't demonstrate that it was practically feasible. He didn't demonstrate that an interlock.
Wasn't that up to the jury, really?
Your Honor, in Amatuli, Your Honor, the Court said that expert testimony has to be supported by reliable facts or data. There are no reliable facts or data in this case.
But what was missing in this case? They have to show that 6 manufacturers were selling an interlock at the time that this item was sold?
That it was reasonably practical, that it would work. No other manufacturer produced an interlock PLC-type device.
Are you saying that the device you sold was state-of-the-art at the time?
Indeed it was, Your Honor. And
if it was, suppose you're right about that, and suppose it's also true that there were ways that were known and were possible to make it safer, but yours was state-of-the-art. Who wins the case?
We win the case, because the standard is not whether the product can be made safer. The standard is what was reasonably
even if it could be made safer at very minimal cost?
Yes, Your Honor.
And what's your best case for that proposition?
Well, I would like to point to the cases that in the Appellate Division case law that's interpreted, Your Honor's decisions.
What about our case law?
Your case law doesn't directly address the issue. McCarthy, Terry Booter.
About Cover?
Cover says that, and let me address the trinity of cases, Voss, Cover against Cohen, and Caprara. These cases say you don't look to what could be done after, except Cover, with the limited exception, duty to warn. Now, warnings was taken out of this case. The trial court, on a summary judgment motion, said these warnings were sufficient to put all users on notice of the danger. Cover against Cohen says one other thing, Your Honor. To establish feasibility, you can look to a subsequent design modification of the same product. Now, the evidence in this record was that the PLC could not be modified. Waymeyer testified that he attempted a mechanical interlock device. He worked on it for 6 to 8 months. It would not work. Waymeyer further testified that in 1989, years later, he attempted to design outriggers with an electrical interlock. He had to design the machine around the new outrigger device. He claims that he participated in the redesign of the AWP. Curtin testified that he was involved, that they invented the AWP.
Who brought the model in? The plaintiffs brought the model in, correct?
Plaintiff brought the model in. not subject to objective testing, just like in the Johnson case where a model was brought into the courtroom and the court held that does not pass muster. That is not a device that demonstrates that this is feasible in the field. 143 of the Respondent's Appendix. Mr. Waymeyer tried an electrical design in 1989. He first designed the outriggers and then designed the machine around it. They have to invent a new machine.
What did Resnick say? I don't want to go through all of my notes, but I mean, I guess I'm just following up on what Judge Graffio said. A lot of people said a lot of things in this trial, and didn't Resnick say this could have happened? Wasn't he their prime expert?
Yes, he said it, but as you know from Amatulli, saying it does not suffice.
But where do we leave off? I mean, we're a law court. How do we decide these issues of fact?
It's very simple, Your Honor. You hold, as you have in myriad cases, that reliable facts and data are the cornerstone of expert testimony. It is not enough to just say it. Demonstrate it. Prove it. Waymeyer testified that he tried to design this device, and Curtin testified that they had to redesign an entire new device. This takes it outside of cover against Cohen. There, the court said that if it can be shown, if that particular product at issue was modified, that could be used to demonstrate feasibility from the time of sale. This product could not be modified. Your Honors, I would point you to a picture of the device, R245 of the record. Plaintiff's expert also said that there should have been a device to store these outriggers. Very small part of the case, and yet much is made of that in the briefs. Your Honors, you don't know from that testimony what that storage device should have been made of, where it should have fit, how it should have been fit together with the rest of the device. It is just an expert saying it, but that doesn't make it proof of a defect.
So you're saying that you should have won at the end of the plaintiff's case? You should have won a motion to dismiss at the end of the plaintiff's case?
Yes, Your Honor. But I'd like to again bring this back to the prejudicial testimony. You see, Your Honor, this case is taken on.
Some of what you're arguing sounds a bit like a weight of the evidence argument for the appellate division.
Well, to the extent that an argument that the evidence presented was entirely prejudicial.
All evidence is supposed to be.
Yeah, but in the trinity of cases cited, Your Honors have held what happens after the sale is not admissible. And this was 11 years of events when we attempt to patent, we being Genie, attempts to design a new product, it's thrown back at us and said, why didn't you do it sooner? Why didn't you patent this sooner? You could have done it sooner. There is no duty to invent sooner. The plaintiff in response to the amicus brief says, point 2, this is not a failure to retrofit case, and yet throughout the case it was. Plaintiff's page 257 of the record, in discussing what this case is about, the plaintiff's attorney, Mr. Gerfine, said, Judge Taub did not say the warnings were adequate. He said plaintiff has failed to put in sufficient proof to sustain a warnings claim. And continuing, he says, it has the evidence to be presented has nothing to do with warnings. It has to do with the duty to the responsibility to do a recall and retrofit.
But, can I ask you the question that I asked at the outset and you said you'd get back to, maybe you're ready to get back to it, why does not the jury verdict on the design defect claim moot the failure to retrofit issue?
Because there was no evidence that this product could have actually been
okay, but suppose we disagree with you on that. Suppose we uphold the verdict on the design defect. Then we don't have to reach any, we don't have to worry about failure to retrofit.
Well, you certainly have to at least remand this for a new trial because all of your cases on this issue hold that the evidence that was presented post-sale is inadmissible. And you say that it takes...
So it was all, assume you're right, it was all inadmissible. They were all wasting their breath with all this about failure to retrofit. The claim should never have been submitted to the jury. How does it taint the verdict on the design defect?
Because it gives the impression throughout. The terms recall, that word resonates. You hear the word recall, you think that the product is terribly dangerous. Now, the restatement of torts third says that there's only a duty to recall when the government agency imposes such a duty.
Where did the taint come from? You're saying the taint comes from the judge?
The taint comes the judge charged on the duty to retrofit.
Yeah, but in the end, you're saying, you're both making your arguments, at the trial, but you're saying the taint comes from the way the judge framed this up for the jury?
It comes from the focus in a products liability case is the product. It is not on the actors. It is not on the acts of the defendant. Judge Fuchsberg held and so stated in Caprara that the acts of the defendant manufacturer are irrelevant. What's relevant is only whether the product was not reasonably safe when sold. That is the focus, the sole focus in a products liability case. And we have 11 years of acts that are used against us, totally in contradiction to Judge Fuchsberg enunciated.
One last question.
One last question. In terms of aggrievement, are you even agreed to come here before us today? You did stipulate to damages.
Your Honor, that was addressed on motion practice, and the court held that there was a jurisdiction to entertain this.
We retained the appeal.
Yes, you retained the appeal and held that you do have jurisdiction to entertain it. I think if you read the motion papers on that issue, you'll see that you properly retained jurisdiction. We stipulated to the damages. We did not stipulate to liability, Your Honors. If this is remanded for a new trial, it's remanded for a trial on liability only.
Okay, you'll have rebuttal.
Thank you, Your Honor.
Yep, thank you.
Do you have the same position on the aggrievement issue?
I beg your pardon, Judge?
On the aggrievement issue that we just raised?
Judge, I don't think this case should be before the court at this point. And I don't think that they're an aggrieved party at this time. Judgment still has not been entered on this case. And, no, this court should not be hearing this case.
Is that because they stipulated?
The stipulation did not create the finality that is required.
You're arguing finality, not aggrievement?
I think that in this case they're the same thing, Judge.
So assuming it is properly here, is the verdict tainted? What the adversary is saying is the whole trial is permeated by this duty to invent or retrofit. Tell us why that's not the case.
Sure. We have never argued that there is a duty to invent. And, in fact, all that defendant...
Do you argue there was a duty to retrofit?
Yes, the word retrofit was used, but as defined by the judge, that was merely a continuing duty to do what they should have already done. There was no post-sale technology. There were no post-sale accidents. And it was only defendants
well,
that...
Why was a separate claim submitted on post-sale activity? As far as I understand it, you're saying the thing was unsafe when sold.
Yes.
And you're not saying that something happened afterwards they discovered that made it unsafe.
They knew it at the time.
So how can you, why doesn't the whole case depend entirely on your first claim, which is that it was unsafe when sold? If you lose that, you lose everything. If you win that, it doesn't matter.
If we win that, it doesn't matter.
And if you lose it, it doesn't matter. If you lose it, you've lost.
I'm not sure I follow that, Judge.
Well, you say that nothing happened after the date of sale.
That is correct.
So if we find, or if the jury finds, or if we find as a matter of law, contrary to your argument, that the thing was safe when it was sold, that ends the case.
Well, it's not for this, respectfully, it's not for this court.
I understand. Suppose the jury had found that. If the jury had rejected your first claim, they couldn't possibly have upheld the other two.
That's
right?
correct.
And they accepted your first claim, and you're telling us it doesn't matter what they did on the other two. So what are the other two doing there?
What's the negligence claim doing there?
Well, what are the post-sale claims doing?
The post-sale claims are simply that the defendants knew at the time of sale that the product was defective. They had a technological correction that they could have made at the time of sale, and they didn't do it. But by positing their theory of a repair that could only be done in the future, it's very difficult for plaintiffs to attack that because, as a practical matter, it's very hard to get discovery on that. But in this particular case, all the technology existed in the Truman era. And, in fact, it's nothing more than one of these interlock switches.
Just at this, whatever might theoretically have happened, at this posture, you agree that the whole case turns on whether the product was, whether the jury could find from the evidence that the product was unreasonably unsafe when sold?
It turns on the strict product liability, that the product was defective at the time of sale, and also the negligence claim that it was negligently designed, that defendants knew that there was a problem, and in fact, all the testimony was that they knew about it.
But your view of this case today, as it's before us, is a straight-out design defect case, and we should stop worrying about whether there is or isn't a duty to retrofit?
That's not raised by this case, Judge.
Okay,
Right, so
this is enough case for the moment.
You're happy with strict liability, you win on that, and you're done.
We win on that and we're done, and I don't think this Court needs to address that additional issue of the continuing duty of care.
Except Mr. Lerner says it polluted.
But there was no evidence that polluted it. And this is what a special verdict does. I mean, any time you win on one case, if this Court were to find that there was no continuing duty, then it's just like any case where a plaintiff wins on one cause of action on the evidence submitted, loses on another cause of action on the evidence submitted. And in the Kavanaugh case, Note 3, this Court held that that was entirely appropriate, that that's what juries do, is sift through the evidence, accept one cause of action, reject if they choose to, another cause of action.
Did the judge submit this in the alternative?
I beg your pardon?
Did Judge Schaefer submit this in the alternative?
Did she submit what in the
The
alternative?
various causes of action?
She did, absolutely. And there was a special, the jury charge was very specific about each of those different causes of action, the elements required, and the verdict sheet also reflects that as well. Interestingly enough, on the record at page 1391, defense counsel, during the charge to the jury, acknowledged that there could be circumstances under which there is a continuing duty of care.
Let me take you back to the design defect claim, since I think you're saying that that's the dispositive one now. Was this product state-of-the-art on the day it was sold?
State-of-the-art means what is feasible.
Is that why? So anything feasible is I mean, if it's feasible to decide to develop a better product than the state-of-the-art, is that better product not what everyone else is selling?
What this Court held most recently in the Adamo case, reciting Voss, was that, if I can quote this Court, it was feasible to design the product in a safer manner. This means, to use again the language of Voss, plaintiffs must show, quote, the potential for designing the product so that it is safer but remains functional.
Okay, but I think what I thought we were saying in Adamo was that is necessary. Are you saying it's sufficient that once you've shown a possibility of a safer design, you win?
If you can show, well, yes, I think that's the law, but also
what about cover? In cover, there was a pending some kind of standard that became effective after the date of the accident, but had already been proposed before the date of the accident. And we held that was inadmissible in evidence, because all it showed was that somebody thought we could do it better. I mean, why doesn't that suggest that the mere possibility of a better design doesn't suffice to get you to a jury?
Judge, in this case, we proved that there was other ways to interlock. In fact, the defense...
I understand that. That's the question I'm asking. You proved there were other feasible, cheap ways to do it. But that seems to me it was true, at least the feasibility part was true in cover, because you had a standard that was already under discussion, that was later adopted. And yet we said that's irrelevant. That just shows somebody had thought of a better way. That doesn't prove.
That's not this case, Judge. In this case, there was a better way that had been manufactured. In fact, defendants owned a competitor's machine that was interlocked, and they chose not to interlock themselves.
I found the evidence kind of, I mean, what do we know about this competitor's machine? What was the name of the competitor?
I don't have the name of the competitor.
Is the name even in the record?
Upright is the name of the competitor.
That's in the record?
Yes, it's in the record, Judge. And they own that machine, they examined it, they considered it, and in fact, the defendant's president told Waymire to go and interlock their machines.
Go do what Upright's doing?
Yes. And they ultimately, they did not do that. And further, Waymire said to the president, there's a problem with tip-overs. And Waymire designed, using off-the-shelf products, a simple switch, an interlock. Our expert brought in the model that was a replica of the machine, which goes 2 stories up in the air and can tip over without these
Okay, but your expert basically said, I took their machine and I put three $25 switches on it and it works.
That's
Okay.
correct.
But but that's different from saying anybody was doing it then. You're saying you had evidence that people were doing it then.
I beg your pardon, Judge?
You're saying you have evidence that competitors were actually doing it back then.
Yes, there was an interlock. And
Okay, let me just, I mean, I'm not doubting, but assume the facts were otherwise. Assume that it was possible to do it, but nobody did it, no standard required it, nobody was, no person was saying it's not, this is not a safe, reasonable way to do it. Can you still win a product liability case?
yes, because the standard requires that it can be done. Otherwise, what
Well,
the
it's gotta be
defendants do
feasible.
is collude with each other,
Feasible and practical.
feasible and practical, and that's for a jury to look at.
So for quite a few years, humanity got along without the wheel. And for maybe a few thousands of those years, it was probably feasible to invent the wheel. You're saying that if we had product liability that day, somebody could be sued for not inventing the wheel?
No, this is not a failure to invent. Interlocks existed. There was no reason why this wasn't interlocked. In fact,
Well, suppose hypothetically, and I know you say it's not true, interlocks no doubt existed. Round things existed in prehistoric times too. But let's suppose that no lift like this with an interlock existed. I know you say that's wrong,
not the
and I
case.
understand that. But suppose they didn't. Do they have a duty to, I won't call it invent, do they have a duty to come up with one?
to invent an interlock,
No, an interlock's existed. Assume none had ever been attached to a machine like this before.
well, okay, that's not the case in the facts.
I understand you now.
And Mr. Waymeyer had
Okay,
always
I
interlocked all
believe
of
I
these.
heard you say that, and I'm not ignoring it. Take the hypothetical. Suppose there was no such thing. Can you win the case?
That would be a jury question. If it was feasible to do and a reasonable engineer would have done it, then it's a defective product if it's not there.
And you can find that a reasonable engineer would have done it, even if no reasonable engineer, whoever existed, had ever done it.
That may be a sufficiency of the evidence, or that may be against the weight of the evidence, which is not available in this case because it was not raised post-trial. There was no sufficiency of evidence raised. The issue raised was admissibility, which has been resolved. In fact, the First Department unanimously found that there was ample evidence of the defect and the negligent design.
If I understand the way these things normally go, what you're supposed to do is eliminate the risk. If you can't eliminate it, you guard it. If you can't guard it, you warn it.
That's correct, Judge. That's the case law. That's the hierarchy of design, that the first thing, and that's what the Braniff case stands for, that the first obligation is to design out the danger, and if you can't design out the danger, to guard against it, and if you can't guard against it, then you warn.
But let me ask you this, because Mr. Lerner spent some time on this, and your expert said that in his opinion, the failure to order a retrofit or recall was a substantial factor in bringing about Adams' injuries because the PLC-24 that was sold to Rath in 1986, and the accident happened some 11 years after the fact, such that Adams would not have been injured had there been a recall or retrofit.
Yes, and what the court then defined recall, which is a continuing duty to make the repair that was available and doable to a danger that was known at the time of sale and prior.
Is that the law in the state of New York, that there's a continuing duty on all manufacturers to do something like that?
It is the law, because that's the law in the First Department, and no other department has spoken on that issue, and so that is the law in New York State.
How long has it been the law in New York State?
I would say back to Power, when the language from Braniff was adopted by the First Department. I also will point out that this Court has cited Braniff without any limitation on the language or correction to say that it wasn't the law. And that rule is the rule that makes sense. That's the rule that best describes the duty.
What do you do-
Otherwise, I'm sorry, Judge.
What do you do when this PLC-24 gets sold, a second time to the third user, and the defendant has no knowledge of where these things go?
That's a different case, Judge, and this Court has ruled on the issue of casual sellers and secondary sellers. And in that case, depending on the facts, there may or may not be liability. But the manufacturer is the one in the best position. The manufacturer was the one who knew that tip-overs were occurring, and it was the manufacturer who failed to move. And further, with respect to the continuing duty, it doesn't make sense that manufacturers get the benefit of selling a defective product by then lowering their duty. by selling a product that they know at the time is defective, that they have the technology to repair, then the solution for them is to sell the product, and their obligation goes down.
But your case here was not a knowledge case. It was a strict design defect.
Both, Judge.
Okay.
The jury found for the plaintiff on strict product liability, and the jury found that the product was negligently designed in a negligence cause of action. The trial court reviewed that and found that there was more than sufficient evidence for both of those items. There was no, in terms of the evidence that was admitted, because the trial court noted that the defendants never raised sufficiency of evidence. They raised the admissibility of evidence. And that issue is resolved and not before this court at this point. The First Department found there was abundant evidence of the defect, and there's nothing for this court to decide because those verdicts are completely sustained by the evidence. Further questions?
Okay, thank you, counsel.
I mean, do I have 30 seconds left?
You've got 30 seconds.
This is not a duty to invent case. Defendants would have you believe that's what it's about. That's where they need to go to win their case, but it's not a duty to invent case. Thank you.
Okay, thanks, counsel. Counsel?
Your Honors, plaintiff's expert testified that this PLC complied with ANSI standards. The only standard in this case is the ANSI standard.
Were there competitors with interlocked outriggers?
There's no identified product. There is the word upright. I'm not sure what that refers to. I don't know the make. I don't know the model. I don't know if Upright is a real company. There is the word upright.
Did you try this case? Did you try this case?
No, the gentleman who tried it is.
I mean, I'm not trying to be flip. I just didn't know when you talk about what was in the record. I didn't know if you were talking about.
It is not in the record what this upright is. What is stated is that it had captive outriggers, which is an entirely separate product. Plaintiff posits that this is a simple switch. Just put a simple switch on it. But let's look at Waymire, page RA 220 and 221. When they put the AWP, they patented a new product.
I don't mean to interrupt you on this, but there are so many products. I think every plaintiff says an interlock. You can put an interlock on a toothbrush, and it'll say, it'll sound plaque. I don't know, but they come up all the time. But isn't that factual? I mean, how do we say that one of these guys is right and one of them's wrong?
Because testimony has to be supported by reliable facts or data. 221 of the record. Waymire testified that the interlock that was used on the AWP when it first went into production failed. Dirt would get in, and it would fail. This is not so simple that one can just put it on and
What did
it's going to work.
Raznick say? What did Raznick say?
Raznick said, just put on an interlock. Now, they both agree, Waymire and all the experts agreed that this outrigger had to both sense that it was inserted in the socket and also would have to sense that it was screwed down and secure on the floor. If not, and this is what the AWP patent does, it works, it only allows the machine to rise if it senses that it's the outriggers are both properly inserted and snug to the floor. They have to be screwed down so that the machine does not wobble. The outrigger that Raznick suggested should have been employed on this product did not sense that the outriggers were secure to the floor. And he acknowledged that that itself posed a risk because the machine would wobble. And he acknowledged that if it wobbles, it's dangerous.
He said with a reasonable degree of engineering certainty, the PLC-24 should have had an interlock switch, as such switches have been around since 1868. In this case, an electrical interlock could have been incorporated into the design to ensure that the outriggers were in place. If a switch was depressed by an outrigger, the power would go to the machine. If the switch was not depressed, the machine wouldn't operate. Now, what are we supposed to do with that testimony?
Look at it and say what supports the proposition that a durable switch could have been put on the PLC. There's nothing to support it.
We're supposed to search the record and come to the conclusion that this testimony is false.
Unsupported by the evidence.
Unsupported
Judges do that all the time.
Okay.
And you so held in Amatuli, Your Honor.
So you moved, did you move to strike this testimony?
We moved at the close of I don't have the cite from the record, but the defendant defense counsel reserved all motions.
Do you move
Yes.
for a directed verdict?
I believe we moved for a dismissal at the close of the plaintiff's case. Now, plaintiff has put out some conspiracy theory by saying that, and I think you may have had to be listening carefully to say that the industry could conspire to have lesser standards. Mr. Rasnick testified that the ANSI, the American National Standards Institute subcommittee for this product, the A92.3 subcommittee, the committee comprised the Society of Civil Engineers, the American Hotel and Motel Association, Hotel Safety Group, International Association of Government Labor Offices, the National Safety Council. These are the organizations that formulated this standard, which everybody agreed this PLC model, this Model 24 complied with. There was no breach of a duty here. This was in full compliance with the standards. Also, I'd like to conclude by noting that even OSHA acknowledges the ANSI standards. It's at 22 CFR 1962.453 holds that a PLC model, a man lift of this type, if it complies with the earlier 1969 standards, is sufficient. So this complies with all standards. That's in the record.
Okay, Counsel.
I'd ask Your Honors to hold that there is no duty to retrofit and dismiss this case. Thank you, Your Honor.
Okay, thank you.